Tonight's hearing ripped open a question that Washington has tried desperately to avoid. Did the Justice Department follow the law when it charged Donald Trump, or did it bend its own rules to make the case fit the target? In a blistering exchange, a member of Congress confronted Special Counsel Jack Smith with the one issue prosecutors fear most: intent, bias, and the real standard for indictment. Was there actual proof Trump knowingly committed a crime? Or was this case built on speculation while prosecutors ignored the fact that he was receiving conflicting legal advice from multiple advisors? The tension exploded as lawmakers suggested something even more explosive: that Trump may have been individually targeted in a prosecution that never would have happened to anyone else. And as those accusations piled up, selective justice, political timing, and a possible collapse of the Justice Department's own rules, the room grew visibly tense, with Smith forced onto the defensive, scrambling to insist the evidence and timing followed DOJ policy. But what happened next is where the story really turns. Because in the clip you're about to see, Jack Smith is pressed harder than ever, and the answers raise even more questions. Stay with us, because the details are explosive. And before we dive in, make sure to like this video and subscribe to the channel so you don't miss the next breakdown of the moment Washington doesn't want you to see.
Gentlelady from Florida is recognized for 5 minutes.
Mr. Smith, you have a long tenure at the Department of Justice. Would you agree with the statement that DOJ charging policies require prosecutors to bring charges only where the admissible evidence is expected to be sufficient to obtain and sustain a conviction? Is that right?
That is correct. That's from the federal principles of prosecution.
And in this case you brought against President Trump, one of the charges you pursued was under Title 18, Section 371, which requires an agreement to interfere with the lawful function of the United States through deceit or dishonesty that the defendant knowingly and intentionally joined, and an overt act. And what I'd like to ask you about is this. So you would agree that Section 371 requires dishonesty or deceit and also proof that a criminal defendant acted knowingly and intentionally. Is that right?
I believe that's correct. It requires knowing deceit targeted a lawful government function.
So you would then also agree, would you not, that opinion, disagreement, or even mistake is insufficient to satisfy the burden of criminal intent set forth in that statute?
A mistake certainly would. We needed to prove and intended to prove at trial that the false statements that Donald Trump made were knowingly false.
That they were false and that it was done knowingly. So even under your theory of the case, even if we took your facts as true, you still would have been required to prove that the president said something false and that he did it knowingly. So going on to your next charge, let's talk about obstruction. There too, that charge requires proof of wrongful intent, does it not?
That's correct.
So if a defendant there actually believes a factual claim is true, that would mean he could not be convicted of that charge. Isn't that right?
Well,
not correctly convicted.
The defendant for that charge would have to behave corruptly, and corruptly could include seeking an unlawful benefit, seeking a benefit to benefit themselves, in this case, to stay in office when they had, in fact, not won the election.
But there, too, there's a requirement of intent, that this conduct must be knowing and intentional. Isn't that right?
There is an intent requirement, yes.
And didn't you also acknowledge in your deposition that the president was receiving information from multiple advisors? Giuliani, Eastman, Clark, Powell, and in your deposition you said he was almost just regurgitating what they told him. Isn't that right?
I don't believe I said he was regurgitating what they told him. I think what I said is that he was making knowingly false claims, that he was believing anything that would keep him in office, and he was rejecting anything.
You would agree that those people, or some people, were giving the president conflicting advice at that time, would you not?
You are correct in that his original campaign staff told him he had lost. He fired them and brought in people who would...
But criminal liability, under the statutes you used in your indictment, requires proving intent, not simply the undermining of democratic norms or expressing an opinion with which you do not agree. So is it not correct, sir, that here you charged 2 intent-based crimes without any direct proof whatsoever that the conduct charged was knowing, intentional, or that you were going to have an adequate basis to sustain a conviction at trial?
I felt we had proof beyond a reasonable doubt. I felt that that proof included direct testimony from a number of witnesses to prove the knowing falsity of his claims.
Despite the fact that in your own deposition you acknowledge the existence of conflicting advice. If this defendant were anyone other than Donald J. Trump, Mr. Smith, I find it hard to believe that we would be sitting here today having a hearing about an indictment that was returned knowing that the elements of the offenses could not be demonstrated. Now, let's talk about this. I assume you're also familiar with the Department of Justice policy that prohibits prosecutors from selecting the timing of investigative or prosecutorial actions for the purpose of affecting any election.
Yes, I am. That's the election year sensitivities policy, and we followed it in all respects. The public integrity section who administers that policy concurred that we followed it in all respects.
Mr. Chairman, my time has expired.
What this exchange exposed was not strength, not clarity, and certainly not the clean image of justice that Jack Smith and his defenders have tried to sell to the public. What it exposed was a prosecution now dogged by the same questions they never wanted asked out loud. Did this case actually meet the department's own standards? Was intent really proven the way the law requires? And why does it look so much like the rules became flexible the moment the target was Donald Trump? Those are not minor questions. Those are wrecking ball questions. Because when prosecutors ask the country to trust them, they do not get to hide behind vague talking points, selective outrage, or polished television language. They have to prove that the evidence was solid, the standards were consistent, and the timing was clean. And in this hearing, that confidence looked badly shaken. The more the questions drilled down on knowledge, bias, intent, and conflicting advice, the more the entire structure started to look less like an ironclad case and more like a political gamble wrapped in legal packaging. That is why this moment matters so much. It is not just about one defendant, one prosecutor, or one headline. It is about whether justice is being applied evenly or weaponized selectively. It is about whether federal power is being used carefully or carelessly. And it is about whether the public is being asked to accept a lower standard simply because the political atmosphere is so toxic that too many people have stopped demanding fairness and started cheering for outcomes. That is dangerous. It is dangerous for the country, dangerous for the credibility of the justice system, and dangerous for every future case that will now be judged through this same cloud of suspicion. If the law is going to mean anything, it has to survive hard questions, tough scrutiny, and public doubt. If it cannot survive that, then somebody has failed, and failed badly. So do not let this moment get buried under spin, partisan noise, or empty slogans from people who expect you not to notice the cracks. Keep watching, keep questioning, keep pushing back, because the truth does not reveal itself when powerful people are protected from scrutiny. It reveals itself when the pressure gets so intense that the carefully managed story starts to fall apart. And that is exactly why this video matters. So if you believe these questions deserve to be heard, if you believe accountability should apply to prosecutors too, and if you want more fearless breakdowns that cut through the noise and go straight at the facts, hit like right now, subscribe to the channel, and turn on notifications so you do not miss what comes next.